right, conversations go south.
Yeah.
Take us to hearings, take us to trials. What are the common hearing issues about? And then how do these trials work out?
Yeah, so as far as trial is about forget what happened, is what you can prove, right? So you gotta get...
That is the fucking best way I've heard of. You're gonna put that shit on a shirt. Yeah, write that shit down.
Forget what happened.
Forget what happened. It's about what you can prove.
So you gotta get your evidence together. You must make sure to survive the hearsay rules that we're talking about, right?
Okay.
So when you bring a statement, you cannot bring it for the truth of the matter unless it's that person saying it. So get your evidence, get your screenshot, get your audios. I tell my clients, before trial, I don't tell them to go and do surveillance and gather intel, but I tell them what would be helpful at trial. If we have a screenshot of her saying all of this, if we have an audio of her saying all of this, one case that I'm really proud of, after a 4-year court battle, we got a father joint custody.
4 years.
The only way we got it though, he had her on video, her throwing dishes everywhere at his head, attacking him, trying to take the phone. And even with all of that, we could only get joint custody.
Would you encourage your clients to only have communications with their ex-spouses through email, through text message, or does it, as long if
it depends on the specifics, right? When she's suing, or let's not make it she because it's not fair, but when they're suing you, they them. When they're suing you for an order of protection or whatever it is, you got to treat them like the cops, man. They're like on intelligence collection mode, right? And I say women because women just seem to be smarter when it comes to that. They're right? Collecting the evidence, and when they come there, they'll present it better, right? So even though the guy's like, yo, she's like swung on me 20 times, the one time you kind of shove her a little bit or you bump her, that's when they go to court.
Well, as a male rights activist, I completely understand and empathize with it. No.
That was right. Hey man,
I mean, this is
just start
but there
5 words into that sentence.
I was definitely joking.
Cut it back.
Okay. But it does open this interesting, like, there is a presumption of I guess wrongdoing for that the male party has to kind of
guys just don't seek government intervention as much. They try to work it out, even when they get even when they are the victims of whatever. They kind of try to, like, that's the mother of my children. I'm not gonna get her mixed up. Whereas women, that's how they kind of respond. Right?
Men sacrifice, right? Like the traditional roles, a man must sacrifice. You sacrifice time, you sacrifice work, you sacrifice your body for your family, whatever it is, right?
Correct.
And so if your wife is having a bad day, given that your wife has the children and makes life, you give her grace, right? That's how we were all raised, right? And we know traditional heteronormative value, right?
Correct.
But that's not necessarily what we're in anymore, right? And there are people who believe they should have the ability to hit a woman back. The courts don't agree in general. And in family court, there's going to be an issue.
If there's bruises or any sort of evidence, you get locked up, automatic.
The thing about it is, we're talking about, this is the order of protection petition. It doesn't refer to the custody petition, which is what we were talking about a moment ago. When you're doing an O petition, if she says he's hitting me, and he says she's hitting me, okay, they're going to order. He didn't file a petition, but that doesn't tend to disprove that he's hitting her.
Correct.
So she's going to get her O petition, right? Like they're going to say, okay.
And that's a relevant factor when you consider custody, violence, interpersonal.
And they're going to do that one first. They're going to do that one first.
Oh, big advantage.
You know, like, so a lot of look, there's a lot of cases where the other side can't file an O petition. They have no evidence of any wrongdoing. And they can't even remember an incident where they were scared of this person, intimidated, hurt by this person. And so the other person is abused. They've been abused. They have evidence of abuse. They have police reports. They have domestic incident reports. They have actual arrests on file, which, by the way, sufficient for the preponderance of the evidence. The mere fact they were arrested, charged, and prosecuted.
No. That means preponderance of evidence of what? That they committed a crime?
Isn't it more likely than not that that person's committed a crime if they've been brought to court, prosecuted, and an order of protection already been issued?
I like to think no, but they consider it.
Most
yeah.
judges will
So if you
accept it.
move first, you just it's just
If you move
it's
first
just-
with an
90%
arrest,
is done.
99% of the
It's
time
done.
you're getting an order of
It's a
protection.
wrap. Unless
Now-
you got money to like chip away at it for 2-3 years, you're as much.
Well,
as
okay, but I mean, so let's.
Interesting.
So you're getting an order of protection after the finding of fact. So you're saying
no,
after,
you get it from the rip.
No, I know that.
Just
But
from
but like
Just
after,
for saying.
He's
after,
talking about
The final one?
yeah, the final one.
Yeah,
So
yeah.
because like we kind of skipped over hearings. Fuck hearings, right? I don't know. Like I don't know what hearings happen in family court, but we kind of went straight to trial.
We said what happens after the conferences.
Is the hearing, yeah.
That's hearings.
That's the fact finding here.
If you can't resolve conferences, you go to
But
hearings.
I guess so. Wasn't there like baby hearings and then the fact
Only
finding?
if necessary, if needed for specific issues.
Traverse hearing,
Yeah.
maybe you have an evidentiary issue
Yeah,
that you want to
yeah,
resolve prior
yeah.
to an actual.
Oh, okay,
It's
okay.
only about legal issues, but they have to be raised in some way before
Yeah.
the judge.
Okay.
But the first thing that'll happen is if you have a no petition, you do that one first.
Yeah.
Deal with that issue.
Okay.
Now, if you get a no petition ordered, and it's for you and the child, it's going to make that custody hearing go a lot smoother, isn't it?
Yeah.
Yeah, you're smooth sailing from there, man.
So
Yeah.
it's a big fight about, did you hurt this woman? Did you follow her? Did you threaten her? Did you violate this order of protection that we issued and the ones issued by the criminal
So you
court?
give up custody and then they agree to withdraw the petition.